5 seconds to go. Start. This appeal arises out of the judgment of a division bench of the High Court of Delhi dated 15th July 2022. The appellant invoked the writ jurisdiction of the High Court seeking its permission to terminate her pregnancy before the completion of 24 weeks on 15th July 2022. Other ancillary reliefs were sought. For convenience of reference, the reliefs claimed before the High Court are extracted below. Permit the petitioner to terminate her ongoing pregnancy through registered medical practitioners at any approved private or government center or hospital before 15th July 2022, as her relief will be infructuous after that, as the pregnancy will be of around 24 weeks by that time. Restrain the respondent from taking any coercive action or criminal proceedings against the petitioner or any registered medical practitioner terminating the pregnancy of the petitioner at any approved private center or hospital registered by Government and City of Delhi. Direct the respondent to include unmarried women also within the ambit of the Rule 3B of the Medical Termination of Pregnancy Rules 2003 as amended on 21st October 2021 for termination of pregnancy under Clause B of subsection 2, Section 3 of the MTP Act for a period of up to 24 weeks. Order an immediate interim relief of stay during the course of proceedings. The appellant is an Indian citizen and a permanent resident of Manipur. She is currently residing in New Delhi. The appellant averred that she is the eldest amongst 5 siblings and that her parents are agriculturists. At the time of the institution of the writ petition before the High Court of Delhi, the appellant was carrying a single intrauterine pregnancy corresponding to a gestational age of 22 weeks. The appellant is an unmarried woman aged about 25 years and had become pregnant as a result of a consensual relationship. The appellant wished to terminate her pregnancy as her partner had refused to marry her at the last stage. She stated that she did not want to carry the pregnancy to term since she was wary of the social stigma and harassment pertaining to unmarried single parents, especially women. Moreover, the appellant submitted that in the absence of a source of livelihood, she was not mentally prepared to raise and nurture the child as an unmarried mother. The appellant stated that the continuation of the unwanted pregnancy would involve a risk of grave and immense injury to her mental health. The appellant sought permission to terminate her pregnancy in terms of Section 3(2)(b) of the Medical Termination of Pregnancy Act 1971 and Rule 3(b)(c) of the Medical Termination of Pregnancy Rules 2003 as amended on 12th October 2021. The appellant instituted a criminal miscellaneous application for grant of interim relief to terminate her pregnancy during the pendency of the writ petition. By its order dated 15th July 2022, the High Court issued notice restricted only to prayer C of the writ petition and rejected the criminal miscellaneous application, effectively rejecting prayers A and B. The High Court observed that Section 32B of the MTP Act was inapplicable to the facts of the present case. Stop.